All right, good evening, everyone. It is, no problem, 5:30. I'll call this policy committee meeting to order. Ms. Schopp, may I have a roll call, please?
Yes. Craig Schneider,
Present.
Megan Miller,
Present.
and Amy Levy.
Here.
All members are present.
Thank you. Is there a motion to approve this evening's agenda?
So moved.
Second.
All right, there's a motion and a second. Is there any discussion? Hearing none, all in favor, please say aye.
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 All right, that motion passes unanimously. Thank you. Is there a motion to approve the minutes?
So moved.
Second.
All right, is there any discussion? Hearing none, all in favor, please say aye.
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 All right, that motion passes unanimously as well. All right, we have a robust agenda, so we're going to jump right in with policy 411, and we'll also look at 411.1 before we entertain a motion. Board Member Schneider, I'll start with you. Policy 411, and we'll take this one page at a time. Any questions or edits on that first page?
I have no questions or edits, as this is much more pertaining to a legal document, which has already been vetted in the past.
Okay. Board Member Miller, same question.
Yep. Same.
All right. I just have a couple points of clarification. In the second paragraph, it says the school district of Beloit will consider requests for reasonable accommodations for a student's sincerely held religious beliefs with regards to all examinations and other academic requirements. When we're looking at, and for those who don't have the policy open at home, we're looking at 411, student non-discrimination statement and complaint procedure. Do we have any language that speaks about dietary concerns or fasting that are connected to religious beliefs, and do we make accommodations for that?
That's a good question. I didn't think about that being part of this statement, but we would make accommodations based off of the need.
Okay. Does the administration, do you, totally, I'm fine either way. Do you think it's prudent to include language, just saying that, the accommodations can be discussed and made available? Or do you feel confident that students that may be a concern for will read this policy and may inquire on their own?
I think we would, that they may inquire on their own if that's a need, and we would honor that.
Okay.
So that's the way I look at this part.
Okay. And then if we go down to the second stanza under that, inquiries or complaints regarding the interpretation or application of this policy shall be referred and processed in accordance with established procedures. Could we clarify that and outlined in this policy? Is anyone opposed to that? Okay. And then if we go down to the next portion, the board also recognizes that reasonable accommodations with regard to examinations and other academic requirements may have to be made from time to time because of the student's sincerely held religious beliefs. And then if we go down written requests, it's based on state and federal guidelines. Could we cross-reference those at the bottom if those are nodding? I wasn't sure if that information was included in what's already listed in the cross-reference.
So cross-reference the statement to the...
Well, it says written requests regarding the above. So what I just read about accommodations being made, shall be made to the building principal. All written requests shall be judged individually based upon state and federal guidelines. Whatever those state and federal guidelines are, if we could cross-reference those at the bottom, that would be helpful. And then a little bit further in that same paragraph, we have he, she. If we could update that to be consistent to he, she, they. May appeal in accordance with established procedure. Again, just specify outlined in this policy. Do I need to repeat anything, Ms. Shope? Okay, perfect. Just yell if I do. And then under the header of complaints and investigations of non-discrimination complaint, number 2, the student non-discrimination policy and administrative rules will be reviewed each September with all employees. So my question is, are administrative rules the same as admin regs? I didn't want to assume.
I would have to look. I don't know that offhand.
If yes, we don't have to go into how I know this. We literally have one admin reg available on board docs. So they may exist and they're housed somewhere else, but the only admin reg that's available for view on board docs pertains to IDs. So if, let me get the right, if administration rules are the same as admin regs, I don't think we currently have one for this policy. If we do, it's not housed in board docs.
Well, I haven't seen this all. I mean, you probably, because I have to cross-reference. but
Okay.
I would
And
just say-
Ms. Shope, I'm going to lean on your institutional knowledge, and I hope the answer is yes. Do we have like robust and amazing admin regs somewhere? They just don't reside currently in board docs?
So my knowledge of policy is that the policy is the board's policy,
Yep.
and the rules are traditionally the administrative regs because they're how the policy the board has set is carried out. In our district, they're housed together. So it's a little confusing because those administrative rules are the rules for the policies. So where you have policy 320 and then you have policy 320 rule 1, that 320 rule 1 is that administrative rule typically.
So I guess that would go back to the question of our administrative rules and admin regs. So if anyone has it open and they're interested, if you go to the policy tab in board docs, and then next to book, it says policy manual. If you change that to administrative regs,
Yep.
those are separate from rules.
Right.
So, and the way I envision, and Dr. Garrison, I'll lean on your expertise because this is your wheelhouse with the day-to-day operations of the district, is that the policy is the formal framework. But to how to get that thing done, like on the ground, practically, these are the things you need to, like, call so-and-so if you, or whatever. All of those things that shouldn't be housed in policy because they may fluctuate, those are contained in admin regs. So it's beyond the kind of steps of the rules and far less informal, but there to be a tool for staff that need to implement those policies. Yeah, so there is a place in board docs for administrative regulations, and there's one there. It's AR 523.6, identification badges for employees. So back to this policy, because I don't want to get too far off track. Again, if administrative rules is the same as administrative regs and separate from policy rules, I think that would be a perfect place to house that, and it doesn't currently exist. So do we want to leave it in I think it should exist, but do we want to leave it in the policy?
I think we should take it out of the policy if we don't have a reg. You see what I'm saying? If we don't.
But I want us to have a reg.
Well, the policy would tell us to make a reg. I understand that part.
Right.
But I don't want this to be here if we don't have a reg. Otherwise, I'll have to make a reg, which is fine. I'm just saying that this is saying that we have one and we don't have one. That'd be misleading if you ask me. It says admin regs rules will be reviewed each September. If we don't have one, then this is not accurate.
I agree.
So do you. I mean, I can make one. We can We can make one.
Okay.
That's what you want.
Can we put that on the to-do? Well, hold on, let me check. Committee, how do you, because it's not Amy Joyce's decision. Do you feel it, well, the admin reg is listed in policy. Do you believe it's important to fulfill that?
Yes, I do. I think it's listed here, so it is listed here in the policy, so we do need to have an administrative rules for that. We need to just make it easy for all administrators to be able to look at, this policy and what it means and how they need to follow that
Okay.
and the procedures.
Board Member Miller, do you feel differently?
No, I mean, I guess I wanted to defer to whatever makes sense for the administrators. I mean, if it's in there, then we've got to do it, right? So.
Or remove it, yeah, but I think it's important for it to be in there. Okay, thank you. Dr. Garrison, are you opposed to keeping that in there?
If 2 board members say I need to do it, I'm gonna do it. I got 2 saying we want it, so.
No comment, sir. Okay, so my final request, just for consistency, because rules are different than administrative regulations, and administrative regulation is the header for where it's housed in board docs. Can we just change to the student non-discrimination policy and administrative regulations will be reviewed each September with all employees? And that's not something that has to come back to the board unless there's a reason for that policy to be reviewed, but that, and I'm assuming,
Follows the policy.
no judgment, did that happen in September?
Well, if we don't have a reg, so I can't say it happened in September.
But the policy review?
Possibly, yes.
Okay, perfect.
But we don't have a reg, though.
Okay,
Make sure we're on the same page.
absolutely, but we're gonna get one.
We're gonna get one, though.
Perfect. Ms. Joe, can you put that on our to-do list, please? Thank you so much. All right. Page 2, Board Member Schneider, any questions or edits?
I have nothing.
All right. Board Member Miller, same question.
Nope, I thought it looked fine.
Okay, couple questions. The third stanza down, the policy and procedures and the name of the designee will be published annually in a legal notice. Where is that legal notice housed? Like, is that also housed on the website? Because here's the thing, the name of the designee is the person that handles the complaint. And I always like to read the policy through the lens of a parent, guardian, or like community members. So if I have a complaint, how would I know who that complaint goes to? And it's impractical to put a person's name in there because that might change in policy. But where is that information housed?
It's in the family handbook.
The person's name is in there and contact information?
Correct, and that's
Perfect.
updated annually by my department.
Okay. So are you all comfortable with putting, will be published annually in the legal notice and is it the student handbook?
Family.
And the family handbook? Are we okay with that addition? All right. Okay. Perfect. Thank you so much. And then right under that, in January of each year, the school district will file a student non-discrimination compliance report with the Department of Public Instruction. So we are geared up to do that in January. Yes?
Correct.
Perfect. And I don't recall that ever being shared with the board, or maybe just like the highlights of that. Dr. Garrison, I leave that to your discretion.
We didn't do one last year, I can tell you that.
We do the report every year.
Not to the board, though.
And even if it's just in like one of your updates, if there are highlights that we need to be made aware of, or if there are amazing things to celebrate, like things were identified and resolved, or whatever that looks like. Under C, filing complaint, individuals reporting incidences of discrimination will be protected from retaliation and reprisal, including but not limited to. It has a lot of things, and then sarcasm. Oh, no problem. Under C, filing a complaint. So one of the protections listed, all of them were like very clear to me, made sense. Discrimination, escalation, unsatisfactory academic evaluations, threats, differences in academic treatment, and then sarcasm. And we don't have to spend a ton of time on this, but I'm just curious, like how is that enforced, I guess, if someone was deemed to be sarcastic?
Legal review, so they must have been in sarcasm somehow.
Okay, got it. And then my other question, just with process. So a report can be given to any district employee, either verbally or in writing. But at some point, the complainant, let me find it. The complainant will be provided the district's non-discrimination policy, complaint procedure, and complaint form. If the complainant is not the one who's filling out the complaint form, and I haven't seen the complaint form, is there a space on there? So if I come to Ms. Beavers and I verbally give her my complaint, and then she gives me all of the things that are listed in policy, and for whatever reason, I'm not comfortable filling out that complaint form myself, and she assists me, is there a sign-off on that complaint form that the complainant has reviewed it? Because some things can get lost in translation, not just different languages, but just translation. That, yep, this is my intent, this is what I meant, this is accurate. Is there a sign-off on that complaint form?
I can't speak to that. That's
Okay.
a form that's housed in HR. So we can ask Ms. Almendarez and get back to you. She's the Title IX coordinator.
Okay, perfect. Can we put that on the to-do list? Thank you so much. So we'll just check the complaint form to make sure if the complainant is not the one who's filling it out. And I think we should have the flexibility that if someone needs assistance, that I think that's appropriate to do unless the administration objects. That there is like a review and a sign off that they confirm like, yep, this was my intent, this is what, all of that good stuff. All right. Any board members see that differently or have additional input? Okay. And then if we go down to the district shall then contact the parent, where is it?
Last paragraph.
Oh, yeah, it's kind of halfway through on mine. It's above D. There isn't a timeline for, again, and thank you, Ms. Beavers, for allowing me to use you in this example, which I didn't ask permission beforehand, so hopefully that's okay. If I lodge a complaint to Mrs. Beavers, there's not a timeline for when she needs to get in touch with the person who handles the complaint. Because anyone can go to anyone in the district, and then, let me see the exact link, because the other steps has like 5 days, within 10 days, within 15 days, like it's spelled out so we know that we're in compliance. Let me find the exact language.
D1, the last sentence has some time.
Yeah, it says immediately. What does immediately mean? Is that same day? Is that the next day?
Very subjective, in my opinion.
And I'm okay if the administration is okay. I just like consistency, and all of the other steps has like a number of days.
Nothing is immediate, so that wouldn't be consistent.
So is it the same day, within 2 days? Like, what would the administration recommend for when it, because a complaint can go to any, as it's written, any staff member.
Correct.
And all staff in September have gone through it, so this shouldn't be a shock. But then how much time between I get that complaint, and if it's verbal, it has to be transcribed, so we have to account for that. And then it goes to the complaint officer. So what time frame do we want? Yes.
Can I just ask a clarifying question? Under D, investigation, number 1, the very last sentence says, "The district's designated contact for discrimination complaints shall acknowledge receipt of the complaint in writing within 5 calendar days."
But my question is, if the complaint doesn't come directly to her, and it has
Yeah.
to go through another person, how much time do they have before they can give it to her? Because once she receives it, she has 5 days. But if I take 10 days to get it to her, you know what I mean? There's not a,
Yeah, I guess I was interpreting that as like, I receive it, I stamp date it, let's say the 10th, and I give it to Dr. Garrison. He's got 5 days from the 10th, regardless of,
but how much time do you have to give it to him?
I mean, I see it as immediate, but it's,
But what is immediate the same day? Is that the next day?
It just sometimes it also depends on what's being shared too. Like if it's
Yeah.
like an emergency, like this is something that need to have. I mean, I can see immediate looking different. I'm not sure if you can put a time frame on immediate.
yeah, I read that as like within whoever received the complaint, and I can only relate this to like special education paperwork.
That's
like,
fine.
When we receive a referral, it's dated when the district receives it, that starts a timeline. It doesn't matter when it gets to my that starts a timeline. So when I see 5 days, I think 5 days we have to contact the parent from whenever the district that, I don't
So
know.
typically, when something comes to me, though, I mean, you bring up a good point, but typically when something comes to me, I say 24 to 48 hours.
Right,
When I hear-
that's what I think too, in my head.
So, but immediate is not 24 hours. To some people, they want,
Yeah.
they may want something right then.
So how about this? So within 2 business days,
Okay.
and then in the regs, that's something you flesh out in the regs. Like if it's serious, that means same day. If it's this category, you can do that the next day. But I don't think that level of specificity needs to be in policy.
Well, I know what I would say if it's going to be an admin regs, within 24 to 48 hours. After I receive the complaint, my standard practice is I'm trying to get back to you within 24 to 48 hours. Now, that don't always mean that they're going to get back to me after I get back to them, though. So that's the whole gray area from a complaint perspective.
Okay, so let's do this. Because there could be a gap, there could be a whole nother human between when the complaint from the complainant and the complaint officer. That's what we want to address. So let me first, and help me, please, find the language of, okay. Students should,
We are mandated reporters, though, too, so if it's, that's immediate. Something, let's say that rises to the occasion of a Title IX infraction, that's immediate.
I found it, and this might be helpful. So the paragraph that starts, students who believe they are the victims of discrimination. If we go down a little bit, complaints may be made either verbally or in writing to a district employee, so that's any district employee, and shall be forwarded to the district's designated contact for discrimination complaints within 2 days, or we'll just do 2 days.
2 days, yeah,
Everyone okay with that?
that's fine.
All right, Ms. Shope, were you able to identify where I was? Yes. Perfect. All right. All right, next page, Board Member Schneider, same question. Actually, let's just do the last 2, because it's like a page and a little bit.
I have nothing.
All right, Board Member Miller, same question.
Yep, same.
All right. My only point of clarification is once you go through 4A through D, and this is talking about the appeal process. The request for the review must be so let me back up. Number 4 starts off with if the complainant or the complainant's parent/guardian is not satisfied with the conclusion, recommendation, or corrective action, all right? So if you jump down after D, the request for review must be filled within 30 calendar days after the complaint was originally filed. Originally filed or when they received the outcome. Because let's say something happened September 1st, and the process happened, and I got the decision on September 28th. So I have 2 days to do steps A through D because it's after it was originally filed, not after I received the decision. And I don't know if that's a legal thing or if that's something where we have flexibility.
I read this a little bit different because I'm saying it just as it's saying, must be filed within 30 calendar days.
After the complaint was originally filed. So when the complaint is originally filed, you have to get it to the CO. They have 5 days. You have to do an investigation if it's necessary. The determination has to be made. You got to notify the people of the determination. So if that runs out your clock on your 30 days, I might not know that I need an appeal until 25 days in. But if it's 30 days after the receipt of the decision, I think that's the intent, but I don't want to assume.
Well, I think too, it's our goal to move expeditiously through any of these processes. So getting to the 30th calendar day, I mean, I'm not sure if we ever got that deep into.
There's timelines attached to other policies for investigations,
Right.
for the actual investigation piece, and I don't see that on this one.
Well, let me just interject this. It's 5 days for the first step of the process.
Correct.
And then it's 15 days when the superintendent's designee provides a written response. So that's 20 days right there.
So
So
then
within you know what I mean? So is the intent to give someone 30 days from the original complaint, or is the intent to give someone 30 days from when they receive the decision of the original complaint, and then they can process and decide if they want to appeal?
I think it's from the original date.
Really?
Yeah, because it's 2 weeks, you know? It would be an additional 10 calendar days.
Correct.
Okay. Are other committee, committee members okay with that?
Yep.
Okay.
Yeah, I'm fine.
I just want to reiterate though.
Yeah.
It's our goal to expedite these things in a reasonable timeline. So we're not, I know it says 15 days, so we're not waiting till the 15th day. We're trying to be right around 10. I'm just giving you an example.
Right.
So it's not like, our intentions are never to push things all the way to the absolute last day, because this is involving, parents' complaints or
Right.
something very serious, so.
No, I hear that. And then my only other question was, through the steps of the appeal process, so if the CO's decision is deemed unacceptable by the complainant, they can go to the superintendent. If they don't like the superintendent, they can go to the school board. In the things that they need to provide, so it's include a copy of the decision maker's final decision. And then if it goes to the board, it's include a copy of the superintendent's final decision. Would it be helpful, and I'm mainly asking other board members, if it gets to us, do you want the last decision, or do you want all of the preceding decisions that led up to that point? So the CEO and the superintendent would go to the board, the decisions.
It is the superintendent's decision that the board would be using to base its final decision.
So you're fine with not having the original decision?
I don't think that all of the original decisions are necessary, because that's not what we're using for our basis. It could be very helpful in making a final decision, knowing what the process is all along. But ultimately, we are reviewing the superintendent's decision and basing our finding on that.
Okay. Board Member Miller, same question. Do you have a preference?
Yeah, I feel almost identically. Like, I definitely see the appeal of kind of getting the whole view of, like, the whole process. But, I mean, I think if the basis is going to be what did the superintendent say, that's probably fine.
Perfect. All right. And then my final question on this is actually on the last page under F, anonymous complaints. So and I'll paraphrase for the interest of time. Anonymous complaints will not automatically be dismissed, but then it says how they're going to be vetted. And then the ending of the last sentence, and whether those individuals want to pursue the matter. So if we get an anonymous, credible complaint with details, it's just anonymous. If the anonymous, person decides they don't want to pursue it, does that mean the district drops it? Or is that just something that's taken into into consideration? I just wanted clarification on that.
So it's a good. So my thoughts would, it's always based off of what is actually being written, and so we will always, as a school district, act on what's in best interest of student, staff, families, and so forth. So whether it's credible or anonymous or not, we will always act on and what's in the best interest of the students, staff, families, the whole gambit. So it's kind of hard because I don't know what the anonymous theme would be in this situation. Let's just say it was something that's very credible and we need to look into it. It's anonymous. We're going to look into it.
So let me give a little bit more context just to, okay, the factors include the source and the nature of the information, the seriousness of the alleged incident, the specificity of the information, the objectivity and credibility, excuse me, of the source of the report, whether the individuals can be identified who were subjected to the alleged discrimination, and whether those individuals want to pursue the matter. So just my clarifying question is, if we get an anonymous report that Ms. Shope was discriminated against, but the report is anonymous, but she has been identified as the object of the report, and she doesn't want to pursue it, will that deter the district from pursuing it anyway? Is just my clarifying question.
It would not deter the district from pursuing it anyway, because although Ms. Shope may not want it to be pursued, if it's something that we need to pursue, because it could be impacting other individuals.
Okay.
And so I have to look at it.
So do we want to keep, and there is other language in the policy for those following along at home, if the person who is the object of the complaint wants to remain anonymous, like every effort will be made to do that within reason. So that is covered. Do we even need that last portion of the sentence then? Because if someone doesn't want the district to pursue it, but it's serious, the district has the right to pursue it anyway. So are we really, or whether those individuals want to pursue the matter, do we need to keep that?
I think it has to stay because it's still anonymous. So we have to be able to draw this back to why we're pursuing it based off of what we have in front of us. Go ahead.
I think I agree with you. I think you have to leave it. I think if the individual doesn't want to pursue it, then we just go, because this is a formal process. So I'm relating it to, like, there's other policies where you can go and make a formal complaint and you go down this road and you follow the formal process. And if you say, I don't want it to be formal, it's still investigated. It just doesn't follow a formal process. So I wonder if that's what that is referring to. We're still going to pursue it, not in the formal manner and follow like the timeline and all of the ins and outs of the policy. But we would still obviously look into the discrimination piece.
Okay.
That makes sense?
No, I'm completely fine with that. I just wanted to get clarification and make sure I understood it. Okay, so we have some things to follow up on 411. So thank you, Ms. Shope, for making note of those. We'll go ahead to 411.1, but just spoiler alert, we'll hold on to both of those until we get the questions answered. It should be very brief under the next review, and then it's ready to go. All right. Policy 411, harassment of students. Board Member Schneider, we'll take this one page at a time. Any questions or edits?
I have no edits on this one. Again, this is based off of a 411, so it's very similar to that as being a legal document. So I found nothing to edit at this point.
Perfect. Board Member Miller, same question.
Yeah, I mean, I feel the same. That looked thorough.
Okay. Under A, places a student in reasonable fear of harm. If we could just make that language consistent, his, her, their. If we go down a little bit further, the harasser may be another student, a teacher, coach, other school employee, or a visitor to the school. The harassment may occur in any location, on the school bus, in a classroom, in a hallway, in the cafeteria, in the locker. It listed. Can we consolidate? Because as I was reading through it, I'm like, well, what about a bathroom? And so to eliminate identifying all of the places where it could occur, is everyone comfortable with saying the harassment may occur on district property or at school-sponsored events? Because it does talk about excursions and field trips, and that kind of captured all the places. Is anyone opposed to that?
No, that.
No. If we could just modify that sentence, the second sentence to say the harassment may occur on district property or at school-sponsored events, instead of trying to list all these places where it could occur. Anyone opposed to that? All right. And then I would suggest, I always like to start with the definition and then go into the information. So the next section says, for district policy purpose, sexual harassment means, and then it shows all of that. Is anyone opposed to moving that definition up to right under that first paragraph? So up to and including discipline of offenders, and then we go into the definition. And the reason I want that to appear earlier in the policy, because if it's sexual harassment, not just general harassment, then it's under another policy. It's policy 113, and that's under Title IX. And so I don't want people who have experienced sexual harassment to get through this policy and then realize, oh, I need to be somewhere else. Is anyone opposed to moving that paragraph that has the definition and the redirection, if it's sexual harassment, to right after the first paragraph?
No, but now that I actually, sorry, I'm like a beat behind you. Now
You're
that
fine.
we made that previous change with like all school-sponsored events, because we have school-sponsored events that are off campus,
Yep.
would it be, hang on, I just lost the spot, darn it. There was this, I think it's on page 1. Hold on. Sorry, when I went to
You're
switch
fine.
screens, I lost track. Here it is. The harasser may be, see where it lists, like the harasser may be another student, it's just
Yep.
a few paragraphs down on the first page. Okay. Do you feel like it would be, so because we're including visitor to school, what does everybody think about including language about like people who come into contact with our students? So for example, if students are on a school-sponsored field trip, like, I don't know, we're at the zoo or something, and like there's like, there's like a chaperone or I don't really know. I mean, I know we've got stuff like in town where kids, perform at venues or we go to places.
Yep.
If there's like an adult, can this just be like an extra layer of policy protection for like, the rights and well-being of students by people who come into contact with them on school-sponsored events? So like if I am a teacher and I'm taking students somewhere and there's inappropriate adult contact, like it increases, like maybe there's some kind of a procedure then for me to follow to protect my student or document in some way, like if there was like somebody harassing one of my kids on the field trip.
Yeah, that's why I recommend it. And I'll read it again, and then you let me know if you believe it should be different language. So that second sentence would now read, the harassment may occur on district property or at a school-sponsored event. So that kind of broadens the scope. So like you said, if they're at the zoo and something happens, this is the harassment policy, unless it was sexual harassment, and then that falls under Title IX or Policy 113.
Yeah, I mean, does the language, I mean, I know we can't be responsible for human beings that aren't affiliated with the school district. That's why my question is like, do we need to include like an extra listed category of person? You know what I'm saying? Like, because when you're talking about visitor, that to me opens up like, what if there are people around the kids? Like, I don't know. Like, it just.
So you want to add to that first sentence?
I mean, I think I do. What do you guys think about that? Because, like, on the one hand, we can't be responsible necessarily. It's not like I'm going to go after somebody and be like, hey, you're violating a school board policy. But on the other hand, I feel like it would impact the decision making and like arrangements that I make for my students.
And whether or not a
Yeah, I don't know.
complaint is filed and there's follow-up.
Yeah, I'm really asking more of a question. I don't know, board member Levy and Schneider or Dr. Garrison, like, kind of, so what are your thoughts on that? Do we need to include another category of it, or like something about language, like, or any other, like,
How about
person?
this? If it said, other school employee, comma, a visitor to school, comma, or adult that encounters a student off campus at a school-sponsored event. That feels wordy, but that's the intent. Is that where you were headed?
Oh yeah, I mean, that's where I'm at, but I just want to make sure that I'm not being, I want to make sure that I'm in line with the thinking of the rest of the committee.
Dr. Garrison, weigh in, please.
Sure, I'm a no.
Okay.
I definitely don't mind the sentence. I think it captures on district property or school-sponsored events. I think they're on a school-sponsored event, so if something happens, we're responsible.
May I interject with a question? If something happens with someone who went on the trip with you, or if something happened with the person behind the counter at the zoo kiosk.
Sure, this captures everything because you're at a school-sponsored event. If based off of your original statement, to me, that's all I need personally, as a district, I should say.
Okay.
That's all we would need because it captures everything on district property.
So we don't need to identify the individual, we identified the location where it could
Correct.
occur, which will loop in any individual
All the
that
rest
would
of
be
the stuff.
involved.
Correct.
Board Member Miller, are you good with that?
Yes, as
Okay.
long as that translates.
Yeah,
Yeah,
I'm fine with
100%.
that, yep.
That sounds great.
Look at us working it through. All right. Under Roman numeral 1, student racial harassment, again, I like leading with the definitions. Is anyone opposed to the second paragraph there? It is essential that staff, students have clear understanding. If that's bumped up and that's the first information under the header of student racial harassment, is anyone opposed to that?
No.
Okay. Second page, Board Member Schneider, any questions or edits?
I have nothing.
Board Member Miller, same question.
Oh, sorry, didn't unmute. Nope, I'm good.
Okay. My only question, right under that first paragraph, it says the board designates individuals to serve as the district's complaint officer. That's not what currently happens. Like you said, Ms. Almendares is the complaint officer. The board doesn't, I don't think anyone on the board objects to that, but the board didn't designate her or others to serve in that role. So my first question is, are there multiple people who serve or can serve as the complaint officer, or is it one person?
It's multiple people that can serve in the absence of anyone. So my executive team, I could be the person.
Okay.
Say Dee Dee is out, then it could be me.
So
I
I,
could say,
yep.
I've done this before. Teresa, I need you to do X in the absence of.
So I think it's more appropriate and in line with what you are describing to say the superintendent designates individuals to serve as the district's complaint officer.
But I'm just saying this, I'm just sharing this openly.
Yep.
But you all hired, of course, you all hired me. So I think I'm the person that y'all are referring to in this. That's the way I read it. The board designates individuals to serve. So you hired me to determine who's going to do that.
I think that's a bit of a reach. Because for the way I read this is like the board says this person, and this person will serve in those roles. And that's not realistically what happens, and I don't think that needs to happen. The way you're describing it, it sounds like you have the authority to designate who's serving as the complaint officer.
Correct.
Okay. Is anyone opposed to making sure that that's the language is reflected? So instead of saying the board designates, the superintendent designates.
No, I think that's appropriate to
Yep.
make
Okay.
the change.
And you could designate yourself if you need to step in and do. Okay, so that's going to be superintendent. Again, and this might be in the handbook, if we can confirm, if we go down to the sentence under the next paragraph says the policies and procedures and the names of the COs will be published annually in a legal notice. That's in the handbook as well. So if we could just have that language match the previous policy in the legal notice and provided in the family handbook for consistency. And then we have that January thing again. The January of each year, the school district will file the student non-discrimination compliance report. Since this policy deals with harassment, let me back up. Is there a non-harassment compliance report similar to the, okay, then we should omit that sentence? It feels like it was a copy paste from the discrimination policy.
Nope, harassment is part of the non-discrimination report that's submitted to DPI.
Oh, okay. So harassment is captured under okay, perfect. Thank you for that clarification. Then that answers my next question too. Thank you. Just for the optics, Ms. Shope, under 2A, could we do bullet points instead of the boxes there? Thank you. All right. Page 3, Board Member Schneider, any questions or edits?
I have nothing.
Board Member Miller, same question.
Oh, I didn't see anything.
Okay. I just had one note. Harassment unrelated to protected characteristics will be handled under the Code of Conduct. If we could just list that as a cross-reference, since it's named in the policy, that would be great. The very last sentence of that policy, harassment unrelated to protected characteristics will be handled under the Code of Conduct. If we could just cross-reference the Code of Conduct in this policy. All right, so that takes us through 411.1. We're just gonna put that on hold until we meet next. We have some questions to get answered in 411, and then we'll, as is our practice, send those to the full board together. So that brings us to policy. We'll review 412 and 412.1 together and decide if a motion is needed. Policy 412, any questions or edits from either board member?
I have nothing.
Yep, no, you're fine. Yep, 412, school census. Okay. We have 412 and 412.1.
It's on the agenda. Oh,
And you might not have it because there were no proposed edits.
Mr.
Yeah.
Shady.
Yep, I don't have any edits, just a question. Is the census made available somewhere within the district? No, that's fine. So it's very short. The last sentence says, the annual school census shall be furnished to the Department of Public Instruction on or before September 1st of each year. And I'm sure that is happening. My question is that census made available somewhere within the district if anyone wants to review it? Or is it, because I'm not sure what specific information is contained in the sentence, if it's sensitive and like those things need to be redacted, so we probably wouldn't make it widely available and just redact if it was requested. But just for curiosity, there's no wrong answer.
I think we would have to check with Mr. Shady. This is his.
Okay.
See.
Okay,
Okay.
you could review it right now.
Yeah,
It is
there's
two
no
sentences.
revision, so.
No, you're okay. Ms. Shope, could we put that on our to-do list just to follow up on? And again, there's no wrong answer. I don't think that would hold the policy. But I'm just curious, is the census made available somewhere within the district? Thank you. All right, that brings us to policy 412.1, also very short. Board Member Schneider, any questions or edits?
I have no edits.
Board Member Miller, same question.
Nope.
All right, I have a question. Number 1, okay, so for those playing along at home, we're on 411.1, full-time students. Number 1 says, the student is enrolled in the full complement of instructional experiences of the school day in grades K through 8. That sounds lovely. What is that? What is the full complement of instructional experiences? It made me smile. You're fine. Is that like they need to have a little bit of everything? That's your core, your electives, your recess, your...
Yeah.
That's everything.
All right, so we are providing a full complement of instructional experiences, and I'm excited about that. All right, so is there a motion to approve policies 412 and 412.1 to the full board for approval?
Excuse my
Well, for
interruption. If
yes,
there's no
no.
revisions, they don't need to go anywhere.
You are absolutely correct. Thank you.
You're welcome.
Thank you, Ms. Shope. Ignore that question. All right, that brings us to 420, which again was recently reviewed on September 5th, 2023. The reason it's appearing today is that we like to review policies and policy sets, because if we made a change and a policy in that number grouping that would impact this one, we just want to make sure that they're consistent. All right, so policy 420, if anyone was curious why we're reviewing it again so soon. Board Member Schneider, any questions or edits?
I have nothing.
All right, Board Member Miller, same question.
No edits.
All right. Quick question. Halfway down the page, it says students admitted to the district's elementary and secondary school shall present immunization records as required by law. Are there exemptions for that? And if yes, do you think it's prudent to note that? Like if I don't do immunizations for religious beliefs, or are there exemptions? And do you think it's necessary or prudent to say shall present immunization records as required by law unless they receive an exemption?
You guys know, I don't, I see what you're saying, but I ain't gonna mess up on this one. I don't see the issue if the students are. If a parent or guardian comes in with religious beliefs, something saying that I don't take this shot,
Yeah.
we have to work within parameters of the law.
And I totally hear that. And I could go either way, but my preference for identifying that exclusions exist is parents may not be aware of that. And I look at policy as at its best as an informative document that talks about rights, options, responsibilities, all of the things. So if I'm not a parent that's aware of that, this policy could make me aware. So that's why I'm leaning towards put it in there so people are aware. But Board Member Schneider, Board Member Miller, how do you feel about that?
It's not actually exemptions, there's a waiver form that can be
Okay,
filled
so it's a waiver, okay.
Yeah, I mean, I see what you're saying, and so I mean, to me, like, a waiver, I mean, I think, like, anything that's not going to violate, like, a state or a federal law, you could waive. Like, we can waive policy for, like, a lot of reasons. So on the one hand, I mean, I think just, like, the nature of what a waiver is, we don't necessarily need to list it. However, I appreciate what you're saying also about, like, why not just like keep it simple and straightforward, and just like that seems like it would be a high interest item for somebody who is like looking to waive something. Like, I mean, I think if we're going to note that you can waive something, this would be an appropriate place to note it. So I guess I could go either. I would, I guess the language would have to say, like, you know, I would just be careful how you phrase it, because you don't want to just sort of generally say, like, oh, yeah, like, waivers are available, like, we're going to, like, hand them out like Oprah. But, like, I mean, I think, like, under special circumstances kind of thing. You know what I'm saying? Because, like, to Dr. Garrison's point, it's a law that we have to adhere to, right? I don't know.
Board Member Schneider, what do you think?
What is allowable as a waiver is set by the state in law, so I would just leave it as it is.
Okay. All right. So the last paragraph in the last paragraph in the policy talks about expelled students, but then there's one sentence that I'm not certain applies to expelled. So that's my setup. All right. So the last paragraph talks about expelled students. except there's a sentence like right in the middle that says students who qualify as a student with a disability under IDEA or Section 504 of the Rehabilitation Act will be accepted for enrollment in the school district of Beloit in accordance with state law. I think that's standalone from students who have been expelled, if I'm reading it correctly. So if that is accurate, I would actually say that we should move that sentence up to the last sentence of the paragraph before, and then we should put a header on what remains as expelled students. So you know that's what, because everything else in that paragraph refers to students who have been expelled. I don't think, unless I'm missing something, the sentence that I just read that talks about IDEA in Section 4 and being a course, that has nothing to do, you don't have to be expelled to fall under those categories. Does that make sense?
It makes sense, but if you are expelled, we must enroll you if you qualify for with a disability.
Right. Special education services and 504 services have to be provided to the student whether they're expelled or not.
Correct, so I think it's,
So see, that's my point.
Right.
Because if we have to do it whether it's expelled or not, we shouldn't just include it with the information for expelled student.
Correct.
That should be moved out of that section because it applies to all students who are eligible for those services.
I agree. I think maybe just take that sentence and make it a new paragraph right above this one.
Or are you comfortable with adding it to the paragraph that's already there?
Well, the paragraph before is non-discrimination. And so it actually fits in it as I would put it in as its own paragraph, just a one-sentence paragraph.
Okay, I'm fine with that. Board Member Miller, do you have a different opinion? Nope, you're fine.
No, that makes sense to me.
But it flows with the student placement will be finalized under the student's expulsion. If we're going to separate anything, we should make a whole nother paragraph with, keep these two sentences together.
What do you mean, those two sentences?
So
It's
the
one.
students who qualify, the one you just mentioned, and the
Yep.
next sentence to me should stay together because of the 504 documentation connection.
But if you have a 504, you don't you don't have to be expelled to have that. And so when it talks about the student's expulsion documentation, I could have a 504 and not be an expelled student. Does that make sense? Okay. So Ms. Shope, if we could follow Board Member Schneider's recommendation, make that sentence, put it as a standalone between those two paragraphs. All right.
May I make a clarification?
Please.
Okay, so it'll be the paragraph about discrimination, then it'll be the sentence about the students who qualify for IDEA or Section 504.
Yep.
Then we're going to say nothing about the policy shall prevent the district, blah, blah, blah. And then the last sentence about student placement will be finalized upon all those different factors.
That just
expulsion
stays with that
documentation and all
paragraph
of that.
minus that sentence.
That's going to stay with the expulsion part, or that should be a separate sentence because it takes into consideration everything?
As it stands, it will stay with nothing is policy shall prevent the district from denying the admission of a student during term. So it stays with that section.
Okay.
And then my other question, that last paragraph, right after his, her, their, expulsion from another Wisconsin public school, out-of-state public school, or independent charter in Wisconsin. What about an out-of-state charter?
It will depend on what they're coming here under. If they're coming here under 504, we still have to accept them. A student with disability, sorry.
Okay, but and we list kind of the sections, and that's not listed. So would it make sense to include, because again, it says a Wisconsin public school, an out-of-state public school, or an independent charter in Wisconsin. Does all of the information apply if a student is from an out-of-state charter?
With a IEP, yes. We have to verify the IEP, of course,
Right.
because whether you are at a charter school or not, IEPs can be verified.
Okay.
through the
So
state.
does it make sense to list that? Because right now it's not included.
We can list it, that's fine.
Okay. So, and I'm a fan of making that, so independent charter in Wisconsin or out of state. Is everyone okay with that? All right, perfect. All right, so that concludes 420. Dr. Garrison, I know there's a note, but for anyone who's listening at home who doesn't have board docs open, can you just give us a brief update on policy 420 rules 1 and 2?
They're retired as it stands, right, Mrs. Schultz?
Okay.
Those two policies are retired.
Thank you. And then that takes us to policy 420, Rule 4, which again
Rule three?
was,
Rule
yeah,
three?
go ahead.
You
Rule
said
3,
Rule three,
sorry.
okay.
Yep, Rule 3, which was reviewed September 5th. Is anyone opposed to following our current practice of using the title of this policy as a separate header, and we include this with policy 420? You are having a reaction, Ms. Beavers.
As long as all of the language in the rule stays as is. I don't have policy. I'm
Yeah,
just
I
laughing
don't-
because,
Yep, I don't think anyone's, that I'm aware of, correct me if I'm wrong, board members, proposing edits to it, because again, this was reviewed on September 5th. But is anyone opposed to retiring policy 420, Rule 3, like Rules 1 and 2, and using placement of transfer students as the header and including this with the information in policy 420? All right, hearing none, I'm going to write
think that's
myself a
fine.
little note. All right, so is there a motion to move policy 420 as edited to the board for full approval, and also to retire policy 420, Rule 3?
So moved.
Second?
All right, any further discussion? Hearing none, all in favor, please say aye.
Aye.
What did you?
Sorry, I couldn't unmute. I
Perfect. All right, that motion passes unanimously, and that brings us to policy 421. We'll just look at the entire policy because it's a page and a little bit. Board Member Schneider, any edits or questions?
No, the only comment I had at first was the second paragraph where it says outlined in district procedures, but that is referenced cross-referenced at the bottom of the page, so I have no other edits.
Okay, Board Member Miller, same question.
yeah, I'm good.
All right. I just have a question. Okay, so the title is Admission to Kindergarten or First Grade, and then entrance age. Is anyone opposed to keeping the language consistent with 421 Rule 1, which may be rolled into this policy, and saying admission to 4 or 5-year-old kindergarten and first grade? Okay. All right, so if we could just be consistent with that language. No problem. Admission to 4 or 5-year-old kindergarten and first grade. And then
Point of
everything.
order?
Yes.
The title that's being proposed, though, for 421 Rule 1 is just early admission to 5-year-old kindergarten or first grade.
We're
No
gonna get to
4-year-old.
that. We're gonna get to that.
Okay.
Thank you for
Yep.
pointing that out, though. And first grade, because 4-year-old kindergarten is addressed in this policy. Yep, 4 and 5 and first grade. All right. If we can, before we make any decisions about 421, go to 421 Rule 1, And my first question is anyone opposed with following our practice of collapsing Rule 1 into the policy and retiring Rule 1? So let's start there. Is anyone opposed to that?
No.
No, and honestly, most of my notes are like just to consolidate the rules with the policies.
Oh, same page. All right. So
May I
Yeah.
just interject?
Please.
There is a clear delineation, though, that this is early admission procedures, so as long as maybe there's like a header that says early admission procedures.
Looking at this, this could come up. But this is definitely two distinct situations. Early admission. I think policy.
So are you okay with having the umbrella of admissions? And this is admissions, and then these are the specifications for early admissions on the same policy? Or do you feel strongly that you want early admissions to be handled in a separate policy?
Again, we talked about this.
Yeah.
We did.
I don't know where we're at though still.
I think the only hesitation I have, and I mean, I don't know, like, maybe it would come, I just think people are specifically looking for early admission or exemptions to the new first grade statute. And so,
I think we should separate them, keep them separate. That's where I'm at now. Because I know where you are, but I'm also like, well, we get most of I want my baby to come to school early.
My birthday's September 3rd, so I get
right?
it.
Yeah. So,
I
so
get it.
To me, it's like there needs to be something, you go to this policy by itself and read.
How
It
about
could be,
this?
It could be on an umbrella. I understand what you're trying, what we used to be doing, what we're used to doing.
Yep.
But this one is, we get a lot of this, so.
Let me ask you a question. If you still feel as strongly, I think we're good with yielding to the administration if you want to have two separate. Okay, just a suggestion. We keep the title for 421 as admission to 4 or 5-year-old kindergarten and first grade. And the information that's currently listed in 421 gets a header of regular admission. And the information that's currently listed in 421 Rule 1 gets a header of early admission. So it's all admission, but we're very clear on this is regular admission and this is early admission. Does that feel comfortable, or you want them to still be separated?
I prefer them to be separated.
Okay, I am completely fine with that. Here's my next question. Because the rules, if I'm understanding the structure correctly, tell you how to do the thing in the previous policy that this is a rule of. And it doesn't seem like this is what this is. This feels to me like a 421.1, not a 421 Rule 1. Does anyone see that differently? All right. So theoretically, what we would be doing is
Making this a point one.
we would keep 421 with the amended name of admission to 4 or 5-year-old kindergarten and first grade, and then we would retire 421 Rule 1, and that would be renamed 421.1. Now, the current proposed title is Early Admission to 5-year-old kindergarten or first grade. Is there a reason we don't offer early admission to 4-year-old kindergarten? Well, let me back up. Is everyone okay with that? So we would have 421, we'll retire that Rule 1 and have 421.1.
Why do we have to retire it? Why we just can't?
Because you got to know what happened to it.
We're just renumbering it. Okay.
But now that one I'm going to push back on because there is a 421 Rule 1, which doesn't exist anymore. It has been revamped to 421. I like having a record of what happened when. So I would recommend that we retire it and rename it. Is there someone who feels strongly? Because I want to know what happened to 421 Rule 1. Oh, there's a thumbs up from Megan. Board Member Schneider, weigh in.
Is there a way to document in board docs that it's just been renumbered to, so that we know what happened to Rule 1?
Without retiring it?
Yeah,
So in theory, what happens is I still have to quote unquote retire the current policy 421
Rule 1.
421 Rule 1. So that will go into retired policies, and a copy of it with any changes that you've made, being the renumbering, will become the new policy
Okay.
in the current. So there's a record of it.
Right.
So by you saying move to renumber it, you're creating a retirement
Then
of it.
problem
But you-
solved.
But you
Okay.
don't have to say we're retiring it.
okay.
I want to
Okay.
say we're retiring it unless
can.
someone opposes. Okay, thank you.
But-
I appreciate that.
Yeah, but
Okay,
I wouldn't be creating two documents with one being all crossed off and one being
whatever
all
you need
new.
to do on the back end, I trust is going to be beautiful.
Okay.
For the point of the motion language, what we would potentially be looking at is moving on policy 421, retiring policy 421 Rule 1, and renaming it to 421.1. All right, let me finish my note before I forget. Thank you. Okay, perfect. Now that we've resolved that, my next question, do we offer early admission for 4-year-old kindergarten?
We do currently.
Okay, is there a reason that that is not included in the title for the proposed new title?
Because we would like to propose that we do not.
Oh, okay, I'm listening. Why? We are on that policy. We're on what is now 421 Rule 1 that we're going to change to 421.1. We're there. No, you're fine. All right, why don't we want to do early admission for, and I just want to disclose my bias. Again, my birthday is September 3rd, and the September 1st cutoff, and I started early.
I can relate. I have a September 7th daughter. So I.
All right,
yeah.
tell me why.
So this is something I work on with Rochelle Elliott in teaching and learning, and we've been talking about reviewing this policy for years because we follow these students that have met the criteria for early entrance, and they really struggle as they move through the grade levels socially and emotionally because their developmental level isn't at the same level of their peers. We typically have less than maybe 6 students that apply for it, and of those 6, maybe 1, maybe 2 meet the actual criteria. They have to go through pretty rigorous testing to show us that they are a student we would want to consider. So they do an ASQ test, and then they do a full WISC, which will tell us their IQ, and that is step 1. Once they go beyond that, there's some interview. It's a long process, and if they get through, they're 3 and they're in 4-year-old kindergarten, and then they're just younger than their classmates as they matriculate through. And we've just collected some observational and anecdotal data that they really end up struggling, and we've actually had requests for retention then.
Got it. Board Member Schneider, Board Member Miller, any questions on the information we just received?
Nope. Want to
All right,
support the
perfect.
recommendation.
If you'll indulge me, please allow me to very briefly go back to 421. Quick question. So in the very last paragraph of the newly added information, if a child's request for admission to kindergarten or first grade is denied, the district parent or guardian may appeal the decision in writing to the district administrator. The district administrator's decision is final. Completely fine with that. My only question is, because we outline requirements based on the following conditions, like how the student will be evaluated, do we need to include any information about what evaluation goes into the district administrator's decision, or are we comfortable with just leaving it as is? And if people want additional information, I guess they can ask.
So for I mean, so most of the times when this does get to my table, because they do, I'm looking at everything that has already been produced by the team. And unless the parent, the process, unless the parent can show me something different or that's unlike what's produced in the report, it's definitely just a final decision.
So is there like a portfolio that you review, and does that have a name?
Nope, we do, there's different assessments that we do.
Okay.
Formalized assessments. And there's criteria at which, like, they have to score.
Certain numbers.
Do you see any value in clarifying the district administrator's decision? Oh, no, let me back up. Is based off review of assessments and is final? Just so people know what you're reviewing when you make the decision, or are you comfortable with it as it reads?
It's more than that, though. But go
Oh.
ahead, yeah.
Oh,
I just noticed like discrepancy. So I'm going to jump over to 421.1, second page on the bottom. If admission is denied under this policy, the child's parent or guardian may appeal.
Correct.
The
That's what I'm looking at.
superintendent of schools.
I'm looking at the same statement.
Oh, I'm sorry.
Correct.
okay, you're on page
mic was
2,
up.
which,
Rule 1.
Rule 1. Rule 1.
Yep.
At the bottom under
of page 2?
a page, 2 for me, 3, it could be 2 or 3. It's going into
Second
3.
paragraph in item 11.
Thank you.
If admission is
No,
denied-
that's why we review them together.
so
No,
why-
that's the same. District administrator and superintendent, you were saying use the same language so people
Yes.
know?
I'm saying in 420, what we have now labeled 421.1, it says that there is an appeal process to a denial. If admission is denied.
But
under
that's for early admission, that's not regular admission, and is it a different process for early admission than regular admission? Because my whole point was that the process is outlined for early admission of like how decisions are made. Do we want to outline that process for regular admission? That was and there's not a wrong answer. I'm just asking if that is a level of consistency that the administration is interested in.
No, because I look at more than just that, too, because there's some social reports there's some social behaviors that you have to look at. It's
So
a
let
lot.
me back up and just try to make it simple. Do you want to specify what you look at to make that decision? If no, that's perfect. Then it is fine as is. All right. Ms. Beavers, put a pin in what you just highlighted, and if we don't cover it, literally yell. All right. Thank you for indulging me. We are solidly on 421.1, and it seems like board members are fine with us having the nomenclature of early admission to 5-year-old kindergarten or first grade. All right, perfect. Board Member Schneider, any questions or edits for that first page? We'll take it one page at a time.
I just, looking at the page 1, number 1, I know it's recommended to do the cutoff date for the application from June back to May. Was there a time crunch in getting it completed? Okay,
And because of the assessments that we do,
Sure.
the evaluations, getting staff to complete those over the summer is very difficult. Getting to observe a student, that's all very difficult for us to do,
Okay.
to complete.
that's fine. The only other edit would be under number 11 on page 2.
Oh, can we just do one page at
Okay,
a time?
one
Yep,
page there,
yep.
okay.
Okay.
Page 1.
Thank
I'll
you.
move that.
Board Member Miller, any questions or edits on that first page?
Nope.
All right. And Board Member Schneider, thank you for bringing up that point, because my question was why May 1st, and you just explained that. But in previous policy, we specify in the year they propose to enter school. Do you want to keep that consistent language? So by the Central Enrollment Office by May 1st in the year they propose to enter school. just for consistency?
Yes.
Okay, perfect. So we will add that. And then my other question is on that first page, number 4, an evaluation of the child's potential for long-term advanced performance shall be conducted as well. So if you don't, and this kind of sounds icky to say, if you don't show or demonstrate aptitude for advanced performance, you can't start early. What if you test as average? Would you be denied? Or do you have to be advanced?
All of the tests that they have, scores, numbers that we're looking at, considerations. So you may not be at the top of all of those scores and all that, because there's ranges and all that that we have to consider as well. So
It says the evaluations of a child's potential for long-term advanced performance. So does that eliminate students who test, and I get that there's variance, as average? Would you be denied early access if you're not advanced?
you have to meet a real strong criteria. I mean, I don't know how else to say it without being, I hate to say it, discriminatory or whatnot. So there's
Well, and I'm just,
I know, it's a
because
tough
I
one,
don't
'cause
know, so I just want to understand.
it's a very specific criteria that we were looking at.
Yep.
And it's a range. And so not all the students will be at the top of that range for us to not make a determination.
But isn't advanced at the top of the range? Because this policy reads, an evaluation of the child's potential for long-term advanced performance. So if I'm in the middle of the range, if I'm average, does that mean that I wouldn't be considered for early admission? Do I have to be advanced as the policy reads?
Yes, the scores that they're looking at on the intelligence test, the cognitive test is advanced.
Okay.
But there's also, that's one, correct. But there's a lot of tests that we look at, and there's a lot of numbers that we have to consider.
No, I hear
Yeah,
you.
and
I just wanted to make sure that that accurately reflects the process, that the evaluation of the child's potential for long-term advanced performance. They have to score advanced to be considered. And again, this is early registration, not regular. Okay.
It's ongoing. I mean, it's ongoing testing as well. Once they get in and they stay in, we're looking at
So
how our students are doing over time as well. Because a lot of students come in at a possible high level, and then, like Mrs. Beavers already stated, they fall right back into the normed levels at times.
Okay. So it sounds like it's fine as written.
I
Is that
believe it
accurate?
is. I believe it
I
is.
think it is.
Perfect. All right. Page 2, Board Member Schneider.
Okay, second paragraph of number 11. It has the child's parent, open paren,
Yeah, 9.
with the S, and then guardian, it has the 9. We just need to change that to an open paren.
Got it. Thank you so much for catching that. Anything else on page 2? All
That's the only thing.
right. Board Member Miller, any questions or edits for page 2?
Nope, good catch. Nope, that's good.
All right. Under number 10 on page 2, admission or exemption from the Wisconsin mandatory kindergarten compliance requirement will be based on the following conditions. I'm assuming that's a document. Is that accurate? The mandatory kindergarten compliance?
It's a state statute.
Okay. Can we cross-reference that at
I
the end of the
added-
policy since we list it?
I did add it
Okay.
as an addition.
For a cross-reference?
It's on mine.
Or is that
legal.
120.12?
118.33.
Oh, parentheses.
Okay, I see. Okay, I didn't know that was the thing because it's not labeled, it's just the number. All right,
And Wisconsin Act 41 as well.
okay.
Okay.
Perfect, thank you
Did you
so.
call it, I can't see it on the screen that you're showing. What did you call
So
it?
number 10 said admission or exemption from the Wisconsin mandatory kindergarten completion requirement.
Yes. I just thought you read it differently. I just want to make sure it was correct.
Okay, thank you. So that has been cross-referenced, thank you. 10BI, The child was admitted to and successfully completed kindergarten under number 1 above. Well, number 1 above says the parent or guardian obtains the early admission application packet at central enrollment. So I don't think that's what we're trying to
Nope.
communicate.
Michelle, that probably needs to be changed because you did A and B. Yeah.
So what should the reference point be instead of number 1?
I can't see where you're at. Mine looks different than what is on your screen.
So on mine, it's 10BI.
No, I see
So-
that, but what
okay.
does your 5-year-old kindergarten, is that right before 5-year-old kindergarten? Is that a 1? Is that an A?
It's,
It's an A1, so 5-year-old kindergarten is A, and then a Roman numeral 1 for the child demonstrating
So-
social, emotional, physical.
The child was admitted to and successfully completed kindergarten under A above. Because remember, I have,
so can we put 10A Roman numeral I, so it's very clear, instead of number 1?
yeah,
Perfect.
that was miscommunication between me and Michelle.
Okay, and then just, Dr. Garrison, I need you for this one. Sorry. 11, the decision to grant early admission for kindergarten, and it talks about all the things. And then this next paragraph, if admission is denied under the policy, the child's parent or guardian may appeal to the superintendent of schools. The superintendent shall meet with the child's parent. Do you meet with the child? Just the parent. Okay, then we're good. Sorry to pull you back. I just wanted to make sure. That you don't? I think 4-year-olds are delightful. All right. Okay, just a question on number 12, that last sentence, or the last portion of the last sentence, or be expected to meet compulsory attendance requirements through other means authorized by the state. Is there a document that outlines that, or is that included in one of the state statutes that's already cross-referenced? I just like if we mention something in policy that we make it easy for people to find that.
It should be cross-referenced in the statute and the act.
Okay, perfect, thank you. All right, so is there a motion to approve policy 421 with edits? And, okay, is there a policy to approve policy 421 with edits, to retire policy 421 Rule 1, and to rename 421.1 to move on to the full board for approval?
So moved.
Second.
All right, is there any further discussion? Hearing none, all in favor, please say aye. Aye.
Aye.
Any,
Aye.
perfect, that motion passes unanimously. That brings us to policy 422. All right, so just looking ahead, everything in 422 Rule 1 is crossed out. Same for 422. Oh, am I looking at the right one? Okay, let's take it one step at a time. Policy 422 Rule 1 has been included in policy 422, so just a heads up on that. We'll just take the whole policy in its entirety. Board Member Schneider, any questions or edits?
The only question I had is a couple different spots. For example, in the first paragraph, in the third line, schools of the district without payment of tuition, I assume that is a comma?
Should be a capital I on the next.
Okay,
Okay, in addition,
in addition. and
Got it.
I think the same thing may have happened in the first paragraph on the second page, the second sentence, through 12 to attend a public school. And it continues with including an out-of-state school. I'm not sure if that's supposed to be a period or a comma.
and my note for that was through 12 to attend a public school. Is that outside of the district? And then comma, include an out-of-state school. I don't. So Dr. Garrison, we're on the second page. paragraph with the school district of Beloit. No problem. Policy 422. All right, so I'll read through it and you pause me and let me know how it needs to be edited so Ms. Shope can get that down. The school district of Beloit may enter into a written agreement to permit a resident student grades 1 through 12 to attend a public school. Is it in comma, including an out-of-state school or outside the district in accordance with provisions outlined in state law. So is the intent to be to attend a public school, including an out-of-state school or an in-state, out-of-district school in accordance with state law? What is the intent there? And you want to look that over and then we can come back to it? All right, we'll put a pin in that, but we'll get it resolved before we move on. Board Member Miller, any questions or edits for policy 422, knowing that we're going to come back to that last paragraph?
No, that covers my stuff.
Okay. Just structurally, is anyone opposed to, on the first page near the bottom, it talks about guidelines for admitting non-resident students. And just to recap, we're on policy 422, admission of non-resident students other than open enrollment students. Is anyone opposed to moving those guidelines 1 through 3 up to right after that first paragraph? And then what I would also recommend, so the first paragraph as it's printed would say, all students whose parents, guardians within the district Beloit limit. So all of that is our opener. And then if we shifted to guidelines for admitting non-resident students, and then we have 1 through 3, that next paragraph is a little repetitive. The only thing that is new in that, that's not included in the guidelines, is tuition fees shall be charged for all non-resident students admitted except as otherwise provided in this policy. I would ask that we make that number 4 of the guidelines for admitting non-resident students. And I know that was a little convoluted. Did that make sense? Okay, no problem. I was not my clearest self when I described that. So let me try it again. That first paragraph, I think, is perfectly fine as our opener. And then as it currently reads, it talks about non-students shall be admitted to the district only if the school enrollment permits and if the best interests of the students in the school, and then it talks about tuition. Well, if you go down further in the page, it says guidelines for admitting non-resident students. And it lists all of those things clearly. I like the format 1, 2, 3. So the only thing it's a complete repetition except for in the current second paragraph, it talks about tuition. And so I think we should pull that sentence and make that number 4 under the guidelines for admitting non-resident students, and then move 1 through 4 up to right after that first paragraph and eliminate what the current second paragraph is.
If it is educational purposes, it comes up to 4, then you want to move that up after.
Are you visual? Okay, so look at this. Sorry for the mic. This second paragraph is a complete repetition of this, the guidelines for admitting non-resident students, with the exception of the clause about tuition. So instead of repeating ourselves, I love that this is a header and it has the format, and I think this is more clear visually. If we include this last sentence of tuition fees as a number 4 and put that here and move all of this and replace that. Are you good with that? Okay. Right. Ms. Shope, did that make sense? Perfect. All right. So we're going to omit the current second paragraph. We're going to replace it with the guidelines for admitting non-resident students and add the information about tuition as a number 4. All right. So the next thing under guidelines for admitting non-resident students would be if non-resident student admission is granted. So we go through that. So when it talks about providing transportation for students with disabilities, just a question, is there a cost charged to the family for that transportation? So it would be an admitted non-resident student with a disability. Who pays for their transportation? Say again. Okay. So that answers that. And then for number 3, could we just, is anyone opposed to cleaning the language up and saying student is participating in a foreign exchange program? Instead of student is a foreign exchange program student. Is everyone okay with that? All right. Hey, team effort. And so that would remain, that would leave that last paragraph in the sentence that starts with, the executive director of pupil services shall investigate any situation of students residing with someone other than their parent or legal guardian within the boundaries of the school district of Beloit. Is the intention is because they're doing that to avoid paying tuition?
Correct.
Because you're not investigating.
No.
Okay. Does it make sense to clarify within the boundaries of the school district of Beloit to avoid paying tuition? But that's not something Ms. Beavers is going to investigate unless I'm wrong, right?
Yeah.
Well, this says shall investigate. So as I'm reading this, if someone is, okay, let me read. The executive director of pupil services shall investigate any situation of students residing with someone other than their parent or legal guardian within the boundaries of the school district of Beloit. Now, it's my understanding that that is a very specific scope for your role, is if you believe they're doing that to avoid paying tuition. But as it reads, she's investigating every case.
Well, I mean, if you read, it does say if it's for, you're looking to determine the purposes for such residency status, if the purpose is educational, the student will be considered non-resident and will be required to pay tuition. If it's for other than educational purposes, the student will be considered a resident student and will not be charged tuition. So maybe for tuition purposes? What did you say again?
So I said if they're doing it to avoid paying tuition.
It lands negatively to me.
Oh. Okay, I mean, it's under your responsibility, so if you are comfortable the way it's
Yeah.
written, unless another committee member has a different, I'm fine with it. All right. And then that last sentence, tuition fees charged for non-resident students shall be determined using the tuition formula established by state law. Do we have something that we can cross-reference, or and it's difficult when the cross-references just have numbers and they don't have labels. In spirit of full transparency, I didn't click on all of those and read all of them. But is that formula cross-referenced, just so people can have an understanding of what that charge might be?
It's 121.83.
Okay. Can we put established by state law in accordance with state statute 121.83, just so they know which one to go to if they want to find that formula? Ms. Shope, would you add that, please? Yeah, no problem. So at the bottom of the bottom of page 1, that last sentence, the tuition formula established by state law in state statute 121.83. That's the correct one, right, Ms. Beavers?
Yes.
Okay.
Okay, thank you.
All right. Okay, we're at that last paragraph. Dr. Garrison, do you have a chance to look at that? What is the intent? Because our our punctuation is kind of throwing us off. So I will, if it's okay, I'll read and you just stop me when I get to what it should say. Does that work?
It's literally, that is lifted from statute. That's statute language. So.
And it's all commas.
hang
Okay.
on. It's 121.78.
Perfect. Board Member Schneider, you good? I'm good. All right. My final question on this, in that same paragraph, similarly, the school district of Beloit may enter into a written agreement to become the district of attendance for an out-of-district resident. I think I just answered my own question as I read it out loud. All right, I'm good. So let me just check my notes. Okay, that's 422, and then 422.1 has already been collapsed into 422 with the edits. Is that accurate?
Yes.
All right. And then Dr. Garrison, for anyone who's listening at home that doesn't have board docs open, can you give us an update on policy 422.1?
422.1 has been retired.
Okay. And then, Ms. Shope, is there a reason why a policy would be retired but not listed under retired policies?
If they were retired prior to us using board docs.
Is there a note in board docs that says that? Because I call them phantom policies. Like if we're reviewing, welcome to my world, like rule 1 and then rule 6, I'm like, what happened to rules 2 through 5? And then I go to retired and they're not listed. Is there a note? Or can we, if there's, I don't know off the top of my head. Just so people, those phantom policies, there's like some level of explanation.
Well, without going back through this many different years of revisions, finding all of the ones that were,
No, don't find them. But if we just put a note in board docs, like some policies have been retired but may not be listed if they were retired prior to September 1, whatever. So that way people have some, oh, that's probably what happened.
I can try to see if I can find a good spot for that in board docs. I'm not sure exactly where I would put that in relation to policy, because there's not a lot of fields.
Don't worry about it. If someone is really concerned, they can ask and we'll help them out. All right. Okay, so that brings us to policy 422.2, which has also been collapsed into 422. Is that accurate?
Yes.
All right, let me see if I can get this straight. Is there a motion to approve policy 422 with edits? To move on to the, 422 with edits, to retire policy 422 rule 1 and policy 422.2, and to move that to the full board for approval.
So moved.
Second?
All right, any further discussion? Hearing none, all in favor, please say aye. Aye.
Aye.
All right, that motion passes unanimously. We are at 7:11. I'm working hard to get you out in 2 hours. Policy 423. All right, and just a heads up, 423 Rule 1 has been collapsed into policy 423. Board Member Schneider, any questions or edits?
I have nothing.
Okay. Board Member Miller, same question.
Yeah, nothing seemed off.
Okay. Okay, so my only question, no wrong answers, just asking for clarification. Policy 423 towards the bottom, it says the student will be attending as a part-time student and appropriate fees will be prorated. Do we want to keep that language consistent? So they're like, what fees or how is that calculated? With something that says, as determined by the tuition formula established by the state, that exact same language that we had in the previous, just to copy that so people have a point of reference of what they could be charged. Is anyone opposed to that? Well, not even addressing the waiver, but just so people can have an understanding of how tuition is calculated. And then if they need a waiver, that's a separate step. So Ms. Show will pull the same language from the previous policy. The student will be attending as a part-time student, and appropriate fees will be prorated as determined by the tuition formula established by the state, and then we'll reference that state statute. I think it was the 121.83. And then if we could cross-reference that statute, just in case they're not looking at the other policy, cross-reference that with policy 423. Does that make sense? Okay, perfect. All right, here we go. Is there a motion to, did I ask you if you had questions or edits, Board Member Miller? I'm sorry, for 423.
Yeah,
Okay.
no, we're good.
Perfect. All right. Is there a motion to approve policy 423 as amended and retire policy 423 Rule 1? Then move that to the full board for approval.
So moved.
I'll second.
All right. Is there any further discussion? Hearing none, all in favor, please say aye. Aye.
Aye.
All right, perfect. That policy, or that motion passes unanimously. That brings us to policy 424. So let's just start off with the umbrella. Is anyone opposed? Wait a minute. Okay, is anyone opposed? Let me just back up. 424 is state public school open enrollment. 424 Rule 1, the proposed name is admission of students participating under public school open enrollment full-time. And then 424 Rule 2 is admission for students participating under public school open enrollment part-time with specification for high school. Does the administration feel strongly about it, similarly to regular enrollment, early enrollment, that these need to remain separate? Or can we use the proposed titles as headers and collapse Rule 1 and 2 into policy 424? Okay. All right. Well, yeah, but it's just one. Board Member Schneider, Board Member Miller, are you fine with that structural change? And then we can go into any edits.
I am okay with that.
Okay. So again,
I'll get-
sorry, Board Member Miller.
No, I was just saying I'm all good.
Perfect, thank you. So Ms. Shope, if you could use the proposed titles as headers, and then we'll keep the information as is unless there are any edits, which we're gonna address right now. So what is currently policy 424? Board Member Schneider, any questions or edits for that? What's currently contained?
I am okay with it as it is.
Okay. Board Member Miller, same question.
No, ma'am.
All right, I just have one clarifying question. In that first paragraph, it says students may apply for 4-year-old kindergarten, comma, pre-kindergarten. If we're listing 4-year-old kindergarten, is pre-kindergarten considered our 3-year-old program?
I think that should be deleted because we don't,
I'm sorry, could you, your mic's off, could you repeat? You're good.
So I think if we're gonna put pre-kindergarten, I think it should go before 4K, right? Let me see what you was gonna say. You think it should be deleted?
well, we don't, what Mrs. Levy was saying was we only have one school with one 3K classroom.
Correct. But that's still a pre-kindergarten program though.
Can people open enroll into it?
Only if they have that program in their district that they reside in.
Oh,
Right.
In any of those. That's what that's saying right there. Like, you can only enroll in any of those programs if those programs exist. Like, I don't, if Janesville doesn't have 4K, they can't open enroll here into 4K, if that makes sense.
But for the pre-kindergarten, well, first of all, is that the name that we're consistently using, or is that 3-year-old kindergarten? What's the,
I think we say 3-year-old kindergarten.
okay. So step one, we'll replace pre-kindergarten with 3-year-old kindergarten. And Dr. Garrison, you want to move that to be before 4-year-old kindergarten, which makes sense.
What did you want to say?
That's, I mean, it's not a universal program in the district.
It's not, but we still have it though.
Yeah.
That's the issue. I'm stuck on we still have it.
Okay, so how about this if we list it but clarify it? So we're going to change it from pre-kindergarten to 3-year-old kindergarten if it exists in your current district, in parentheses, comma, 4-year-old kindergarten. But let me ask this, why does it have to exist? Let's just use Janesville to stick. Why does Janesville have to have a 3-year-old kindergarten? Because if they had it and it's full, and that's why you want to come to Beloit to be in ours, why did they have to have it in order for you to open enroll somewhere else?
Well, first of all, it's part of, it's part of DPI and the statutes, but if they don't have 4K, they're gonna come into our district and access our 4K.
But we can't, we also get stuck in numbers
Yes.
with that. We get
Yeah.
Because part of, they can't just automatically come. It's if we have space and if it's in the best interest, like all of the things that are outlined in the policy. So I think we resolve that there. But my question, the answer might just be it's state statute and it is what it is. But if I'm in Janesville and I know that Beloit has like a phenomenal 3-year-old kindergarten program,
Right.
but we don't have one, I can't open enroll my child?
No,
Okay, why?
because DPI will tell you you can't. I was on a webinar today.
But why?
I can call them and ask them. I don't know. I don't know the answer to that.
Okay, so for the purpose of this policy, we don't need that, but I do want to know why. Board Member Schneider, you had something?
I think it's because they don't want people opening and enrolling in another district for a specific program with the intent of being there only for that
For a
1
year.
year.
And then leaving
And
it
then
going
going back.
Yeah.
Right, and so it's either you're open enrolling into that district to be part of that district, or you don't open enroll in it,
Yeah.
Okay.
yeah.
All right, thank you for indulging me. For the purposes of this policy, we're gonna change, so is the direction of the administration that we, yes, include 3-year-old kindergarten and just specify if it exists in your current district, in your local district?
I wouldn't add the specification in this portion of the policy because it comes later in the admission, underneath the admissions.
Okay, perfect. So we'll just leave it as 3-year-old kindergarten and then 4-year-old kindergarten. All right. So that takes care of what is currently captured under policy 424. Right now, we're looking at what is included in 421 Rule 1, which is going to become a part of 424, but just so we can have a point of reference. Let's take it a page at a time. Board Member Schneider, any questions or edits for page 1?
Under, let's see, it will be paragraph 4, if a family is planning to move.
Yep.
The third line, it has to attend the district, he or she. If we can just change that to he, she, or their, just to be consistent.
Yep, okay, so we'll change that to he, she, they.
Yep.
Oh, could you point that out again for Ms.
It's
Shope?
the paragraph that begins, if a family is planning to move, it is essential. And it's the third line towards the very end of that third line. The student's ability to attend the district he or she wishes to attend.
Perfect. Board Member Miller, same question for that first page. Any questions or edits?
Nope.
All right, and I am good. That'll take us to the second page. Board Member Schneider, any questions or edits?
The only question I had is under sequence of priority. Under number 1, it talks about the school district Beloit policies and guidelines. Is that cross-referenced at the the end of the article, at the end of the policy. Okay.
Which one is that included with? Is that one of the? Because I see several policies listed, and then the special education policy and procedure handbook.
You're saying sequence of priority number 1, correct?
Yep.
So there is 431, Rule 1, student attendance procedures.
That outlines the priorities.
You're looking for the guidelines in which a student gets preference to their school, correct? Is that what
Yeah.
you're looking for?
Yeah.
Okay. Let me double check that.
Okay, and we can come back to that. Greg, don't let us
Yeah.
forget.
No.
All right, Board Member Miller, that second page, any questions or edits?
No, that's fine.
All right, I am good. That brings us to the third page. Board Member Schneider, same question.
I have nothing on this page.
Okay. Board Member Miller, anything on page 3?
No, ma'am.
All right. Under notice of acceptance or denial, and it's been a long day, so bear with me. The non-resident superintendent or designee shall notify the applicant. So if let's just stick with Janesville. If I'm a student in Janesville that wants to open enroll to Beloit, am I correct in understanding that the superintendent of Janesville or their designee would notify the student whether they were accepted or denied? Is that accurate? Okay, so who notifies them? And does that need to be included in the process? Or does that go in regs? Like, how did they get that information?
That they're not accepted.
Okay, no. If I'm a Janesville student that wants to open enroll to Beloit, so under notice of acceptance or denial, that says that the non-resident superintendent, so that would be Dr. Holzman in Janesville, is going to notify that student. You are shaking your head and I'm coming to you next. Is going to notify that student, yep, you were accepted, no, you were denied. And I asked if that was accurate, and the response I got back was yes. And so my question is, how does he find out? And Michelle is shaking her head. Please unmute.
No, I think, when I read that, the
Yep.
non-resident superintendent would be the Beloit superintendent because you're a resident of Janesville. So the non-resident superintendent would be the superintendent at the district you're trying to go to.
Not the district you're in.
That would
Correct.
be your residence.
Because that's your resident district.
That makes sense.
But sorry, I'm not following where you guys are. I think I'm.
We're
it would
under,
just-
okay, so at the,
It
that
should
makes
say-
sense. The bottom of page 3, notice of, and I'm completely covering my camera with
Acceptance or
my.
denial.
Notice of acceptance or denial.
Okay, I just
So
want to make
yep.
sure it said designee too.
Yeah, so the non-resident superintendent or designee shall notify the applicant.
Yep.
So the applicant is in Janesville for the purpose of our example. And so the non-resident
We do.
superintendent,
Yep.
Yep.
That would be the Beloit superintendent would notify the family that we've accepted or denied.
Okay, see, here's the thing, and it's not that I don't believe you, it just doesn't make sense to me yet. Because the non-resident superintendent, the non-resident student is a student in Janesville, right? So in my mind, the non-resident superintendent is that district's superintendent.
Actually-
Make it make sense, Greg.
If the student is normally a student of Janesville, that's the resident district, and they're applying to open enroll to Beloit, we are the non-resident district. So they're applying here, so it would be Beloit that would actually be notifying them that they've been accepted to come to Beloit.
So it's from the student's perspective. Okay. Dr. Garrison, you good?
I trust the team's decision on this one. That's where I'm at
That could be dangerous, Dr. Garrison, but I support your decision to do that. All right, if it makes sense to everyone but me, I'm good. All right. Page 4 and 5, we'll just take together. Board Member Schneider, any questions or edits?
The only question I had, again, is under notice of assignment, where it established district policies and guidelines. I assume that those are cross-referenced in the bottom of the document.
Okay, yeah, and there are several policies listed, so yeah. Board Member Miller, same question for pages 4 and 5.
No, I'm all set.
All right, I'm good. Okay, so this one had minor edits so far, so we're good. And now we're gonna look at the content currently contained in policy 424 Rule 2 that's gonna be rolled into 424 under using the title as a header. All right.
Can I just
Yeah,
quick add,
please.
the cross-reference policy, Greg, that you were asking about is 432 Rule 2, in-district transfer guidelines.
All right, thank you.
You're welcome.
And that brings up a really good point. Thank you for that exchange. Ms. Shope, as we're collapsing rules into policies, is there a way to search in board docs for things that are cross-referenced? So if the rule has been retired, it directs them to where that content resides, which might be in just the policy, not the rule.
So in this particular case where we've been taking rules and retiring them.
Yep.
And adding the content to the policies. When I move the content to the policy, I move the cross-references to the policy as well. And then if there's a cross-reference to a rule, so I think it's on a previous one we already looked at.
Yep.
There's a note that says remove this rule after approval, which meant because the rule, it was a cross-reference to the rule, to that policy, and that rule was being
Collapsed into the policy.
was actually being retired
Yep.
because the content was moved in. So it was a note to me mostly to say, hey, don't forget to remove this once it's gone through the whole process of approval. So yes, I
Perfect.
am moving those and tracking those and trying to keep those all together.
All right.
But I would like to ask Ms. Beavers what's the number of the policy again? Because I want to make sure that that one is attached,
432 Rule 2.
432 Rule 2?
Yep, in-district transfer guidelines.
Because I don't see that cross-referenced.
That is not currently
No, it's
cross-referenced on 424 Rule 1.
432 Rule 2, did you say?
Yes,
Sorry.
but it's mentioned in the policy, so it should be or the procedure is mentioned.
Okay, so I'll.
So we'll
add
just
it
need
as
to
a-
add it.
Yep, I'll add
Okay.
it.
Thank you for calling out that policy number because now we know it needs to be added. All right, look at us. Okay, 424 Rule 2, Board Member Schneider, we'll take it one page at a time. First page, any questions or edits?
No edits.
All right, Board Member Miller, same question. I'm going to take the silence for you're good. Page 2, same question, Board Member Schneider.
No edits.
All right, Board Member Miller, you there? All right, and same question for page 3.
No edits.
All right, and I am good as well. All right, so is there a motion to approve policy 424 as edited and retire policy 424 rules 1 and 2?
So moved.
Okay, and again, move that onto the full board.
I'll second. Sorry, I got my thing froze, so
Nope.
I could hear you, but it wasn't letting me do anything.
No problem. I'm glad we can communicate now. Is there any further discussion? Hearing none, all in favor, please say aye.
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 All right, that motion passes unanimously. And that brings us to our last policy of the evening, which is a short one. Policy 425, enrollment of expelled students. Board Member Schneider, any questions or edits for that policy?
Second paragraph, second line, public schools, then out-of-state public schools or independent. I assume that's supposed to be charter school, not chart school?
Yeah, it is. All right, Board Member Miller, any questions or edits for policy 425?
No, I was gonna say great minds. That was the only thing I noticed as well.
So my only question is the same area, resident students who are under a pending or existing expulsion order from another Wisconsin public school, out-of-state public school, or independent charter school. What about an out-of-state charter school? Since we kind of list those categories, should we include that?
We can, I mean, I think, yeah, we can, it's not a big deal, because it is a big deal, because you want to be specific.
Right.
I'm also thinking about, when I see these situations come to our school district, we're looking at all that regardless, so we can have it.
Okay. And then, just a question for clarification, how would there be a pending expulsion order? Because you have the hearing and then you have the notification, but,
Happens all the time. What happens is they get the notice
yep.
and they withdraw. And they quick come
Oh.
over here and they try to enroll before the expulsion has gone through the process.
Which most situations as such happens when we're communicating with the other district what's happening with the other student.
So in my mind, emphasis on in my mind, when the board finalizes the expulsion hearing, like it's done. But for the purposes of this, it has to be delivered to the student. Is there a time frame for when do they have to acknowledge it? Or, because I thought that's when the process ended, like.
You're right, but there are times where a family will receive the notice of expulsion for the
Before
hearing.
the hearing, got it,
Yep.
okay.
And so
then
the-
it's pending.
Correct.
Oh, all right.
Yep.
But we also are thinking about, this is how we do it here. In a different district, they may look at this a little bit different.
That is correct, but I was looking at it on the back end, and Ms. Beavers just helped to shift me from so before the hearing occurs, it's pending.
Yep.
And that's the period of time you're
Correct.
referring to.
Yep.
Okay, got it.
But a kid can, this is the one I think we should probably put in a different policy as well. Why?
There's not a rule, though, that we're reviewing, it's just,
Correct.
it's 425.
So, but a kid can still, right in the meeting, they could say, I want to withdraw. You see what I'm saying? And so
Yes.
this is why this policy is this can get a little difficult. But
No, I
understand
think
for
with
the
that,
sake
like,
of what we're talking about, I'm just
with
trying
the context that you're sharing, it makes sense to keep pending in. Because then I was like, well, how is an expulsion pending? Between the time when you get the notice that you need to appear because this process is happening and the board, whichever board, makes a decision. That's that pending time frame, which I wasn't considering. All right. Thank you for indulging me. Okay. Is there a motion to, no, nothing needs to change. See how I caught myself, Ms. Shope? Oh, no, it does. There is a change. Out-of-state charter schools is added. All right. Thank you for the thumbs up, Board Member Miller. Is there a motion to move on policy 425 for the full board for approval?
So moved.
I'll second.
All right. Any further discussion? Hearing none, all in favor, please say aye.
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 All right, that motion passes unanimously. Thank you, everyone. Look at us. We were super productive. Next meeting date is going to be to be determined in January. We have some things that we need to shift around. So that is to be determined. Is there a motion to adjourn?
So moved.
Second.
All right, there's a motion and a second. Is there any further discussion? Hearing none, all in favor, please say aye. Aye.
Aye.
Aye.
All right, thank you, everyone. Great work.
Thank you. Have a good night.